Great, thanks, Steph. So first, I want to thank everybody on this webinar for being a LiveVox customer. As Stephanie said, this is a LiveVox customer exclusive webinar. So in addition to talking about the ruling, I think we can get into some operational details or certainly what we're seeing so far amongst our customer base that we'll get into a little bit later. Jason will get into. That's something that obviously other webinars, can't provide. So so again, thank you for being a LiveVox customer. Thank you for joining this webinar. We really appreciate that. Steph, if you can go on to the next slide, which I believe is a disclaimer. So standard disclaimer, the presentation and the statements of the panelists do not constitute legal advice. We urge businesses to consult with their own experienced legal counsel to independently review the topics covered on today's event and independently evaluate any compliance measures they undertake. Typical disclaimer. We can go to the next slide. So we're going to introduce our panelists. I'll be moderating. My name is Mark Mallah. I'm General Counsel of LiveVox. Been with LiveVox a little over 10 years. When I started, I did not know what the Tcpa was. Since day one, I think I've said Tcpa at least 5 to 10 times every day in the last 10 years. So we live and breathe the Tcpa pretty much every day at LiveVox. Christine, if you can introduce yourself, and then Jason.
Hi, everyone. Thanks so much for having me, LiveVox. I appreciate the opportunity to speak with you and your customers. My name is Christin Reilly. I am head of our Consumer Protection and Advertising Group at Manatt, Phelps & Phillips. I have been doing Tcpa work for as long as I can recall. It is now going on over 10 years, over a decade that I've been working in this space. And I started working on Tcpa before it was really a hot topic. It was back in 2010, before the rise of all of these class action litigations and what now has just become a staple of class action practice. So thanks so much for having me.
And hey everybody, my name is Jason Queener. For those of you that don't know me, I lead our business consulting team here at LiveVox. We obviously partner with our clients for best practices and strategies, and navigating CFPB and the Tcpa, and this ruling is certainly one of those opportunities. So thanks for joining us today.
Great, thanks, Jason, and thanks, Christine, for joining us. We've run into each other, Christine, at a lot of seminars when we were traveling, and I've learned a lot from listening to you, and we really appreciate you joining us. So, Steph, if we can go to the next slide. So the first part of the presentation is going to be the ruling itself. We'll talk about the ruling, what the actual ruling is, some of the things where we could potentially see coming out of the ruling. We'll have a discussion around that. And then we'll go into some of the operational considerations with Jason. So Christine, let's talk about, obviously we're not going to go through the entire ruling, but I think we've identified 4 key takeaways from the ruling that, we should focus on. Can you, just help walk us through these key takeaways?
I'd be happy to. So as everyone knows, this Facebook decision has been highly anticipated. It is a landmark decision in the auto dialer world that we live in. And it is a key ruling that I expect all of us will be using in any auto dialer case going forward. So what you need to know in a very short nutshell is the Supreme Court was looking at the question of what the role of random or sequential number generation is. And basically the Supreme Court came back and said, you can't just read it out of the statute. You can't, which is what the Ninth Circuit was doing and some other circuits as well. So now the standard has become, in order for something to be an auto dialer, in order for your dialing equipment or your devices to be considered an auto dialer, you need to do one of 2 things. One is the device either needs to store numbers using a random or sequential number generator, or your device needs to be able to produce numbers using a random and sequential number generator. In other words, you cannot take away the random and sequential number generation language that Congress actually put into the definition in the statute. and in the regulations that are interpreted by the FCC. So this is a great ruling. It is a very positive result. As we all know, here in the TCPA world, we have had a lot of ups and downs, and the pendulum swings in different directions. And just last week, it's swinging in our direction for once. Now, putting aside what the decision has come out as and what the holding is, I think we also need to think about what are the issues going forward. So you understand what the ruling is, but what does it actually mean? What are the issues that are actually going to be litigated going forward? So 4 issues, primary issues that are going to come out of this ruling, and these are going to be very important. The first is the role of random and sequential number generation. We now have the highest court of the land saying it matters. You can't just read it out. But what I expect to see over the next several months, year or 2 years or more, is a fight over what does that actually mean? What does it mean to store numbers using a random or sequential number generator? What does it mean to produce numbers using a random or sequential number generator? And that's one of the issues that plaintiff lawyers have already identified within hours of this decision being issued on Thursday. They're already pointing to footnote 7 in the decision as being a way to argue that the intent of the decision is much broader and that it is not as narrow as us companies and defendants would like it to be. Specifically, I've had some emails from plaintiff lawyers saying that they think their theory of the case may be that simply to store numbers from a list and then to dial them still is enough, even under the Supreme Court ruling. In other words, if this sounds a little familiar to you, almost like the Ninth Circuit's decision in Marks and in the Duguid case, we might be seeing the same type of arguments being made despite the decision that is a victory for Facebook and for the industry. So I do expect—
Christine,
Sure, go, Mark.
Sure, could I jump in? Just to want to focus on this random sequential number generation. Obviously, there's a lot to talk about. When I first read the decision, I thought, wow, this is pretty straightforward, amazingly straightforward. It was, I was expecting perhaps like a 80-page decision with all kinds of twists and turns. But it's never quite as simple as you might imagine, as you're indicating. But let's just focus on this random sequential number generation. One point I want to ask you about, in different points in the decision, they would say the use of a random sequential number generator, and alternatively, they said the capacity to use a random sequential number generator. So it seems like they're a little inconsistent there. There's a difference between actual use of the random sequential number generator and the capacity to use a random sequential number generator. Can you kind of speak to that? Where do you think it was the court being inconsistent? Was what's the situation? Which way is it? Is it one way? Is it both? How is that going to work?
I couldn't agree with you more, Mark, that you get a decision that's only 12 pages from the Supreme Court, and it seems to be like it wasn't even a hard decision for them. And yet there's all these issues to unpack, and you've identified number 2 on this list here, use versus capacity. It is very interesting that the Supreme Court has, in some instances, focused on capacity, but in other key places of the decision, they don't use the word capacity. They just say use a random or sequential number generator. They even went so far as to say that Facebook's device or their system that was at issue in this particular lawsuit was not an auto dialer because it didn't use a random or sequential number generator. Those are inconsistent. Either you need to have the capacity to do the random and sequential number generation, or you're looking at actually employing the use of that type of generation. I do think that the Supreme Court could have possibly been a little sloppy in terms of some of the language it used, but I also think that these are very highly skilled lawyers that are at the highest court of the entire country, And I just wonder sometimes if some of this was rather strategic, leaving open some debate to be had about the role of capacity. We are going to see litigations get into this very issue. Is it use, or is it just capacity to store or produce numbers? And it matters. It matters in terms of the analysis of whether your system may qualify.
Well, yeah, it's true. Now the thing is, if we have the use standard, it's pretty straightforward. Either you're using it or you're not using it. Fairly, it's one or the other. Capacity, we were particularly frustrated over the last several years with the capacity standard related to the capacity to auto dial. And it's the question, like, what is capacity? Is capacity just, you flip a switch, or capacity, I think of an analogy like, I live in the Bay Area. A lot of people don't have air conditioning here. I don't have air conditioning. Now, does my place have the capacity for air conditioning? Sure, someone can come in here. I can hire a contractor and, rewire the place and set up air conditioning. It's going to take, a bit of money to do that and a bit of time, but it's not like it can't happen. So if, just as a thought experiment, if we go with this capacity standard, and I think today, Jason, correct me if I'm wrong, but modern equipment does not use random sequential number generator. It's pretty obsolete, right?
Yeah, I mean, anybody doing reputable business, that doesn't even exist in any sort of offering on the market.
Right. So if we talk about the capacity to use a random sequential number generator, we're generally talking about a system that doesn't actually use it and that is not equipped with it to easily use it. So how do you see this capacity playing out, assuming that's going to be argued, as you said? What's the argument? How do you see this capacity question playing out?
Well, one thing that's really key here is the U.S. Supreme Court did not decide the issue of capacity. Everyone needs to understand this distinction. They looked at a very specific question about random and sequential number generation. They did not look at the capacity issue. So what I am expecting to happen here is that plaintiff lawyers are going to push the capacity piece of the auto dialer definition. They are going to argue without a doubt that it is not about the use of random or sequential number generation, despite some phrasing in the decision. They're going to point to the statute and the definition that does have the word capacity in it, and they're going to argue that so long as your system has the capacity, whatever that means, to store numbers using the generator or to produce numbers, your system still qualifies as an auto dialer. What does that mean for us? Well, that could be a very interesting and somewhat scary proposition if you're in the Ninth Circuit, for example. And the Ninth Circuit has the worst law in the country on capacity. It almost sounds like it's potential capacity. I'm almost getting, back to 2015 when the FCC came out with their ruling that capacity meant potential capacity. Now, we all know on this call that the DC Circuit said that was unreasonable. But what did the Ninth Circuit do? The Ninth Circuit turned around and snubbed their nose at the DC Circuit ACA International ruling and just went on with what they wanted the law to be and to interpret it very broadly. So my fear is these arguments from the plaintiff lawyers will continue to push the capacity issue, and we may not see as much change, despite a great decision. We may not see as much change in jurisdictions like the Ninth Circuit. I mean, and that's part two to this question, right? You have the US Supreme Court giving us a decision, but now it is about the lower courts looking at this decision and interpreting it. That's where the key law is going to really be had. How is the Ninth Circuit going to embrace the decision? I have a feeling, a sneaking suspicion, the Ninth Circuit has their very strong feelings about this, and they will try to hold to their prior rulings as much as possible, because that is what the Ninth Circuit has historically done.
So it reminds me, the saying, the more things change, the more they stay the same. So we could potentially have a situation obviously I don't know if this is going to happen or not, but we could have a situation where capacity means one thing in the Ninth Circuit, and then it means another thing in the Second Circuit, and we have a split in circuits on capacity, and then maybe in 5 years we got a Facebook 2 by the Supreme Court trying to resolve the split in circuits between what capacity means.
I unfortunately think that that is certainly a possibility. We already know the plaintiff lawyers intend to make these arguments. I've already been doing my own informal poll with the plaintiff lawyers we have cases with, and they haven't been shy about saying what they plan to do, and capacity is an area they're going to focus. So, a lot remains to be seen on what will happen with the lower courts doing their interpretation. But I think you potentially have a situation where we see a lot of variety across the jurisdictions in the country as to what capacity means. We already have a divide that currently exists, so it could potentially change. It might stay the same, but we're having a lot of the same types of discussions we were having before. Because remember, the Supreme Court only looked at one piece of the auto dialer equation. It did not look at the entire definition.
Right. And just to push this a little bit, it seems to me like a stretch to argue capacity for random and sequential number generator when we know that the random and sequential number generator hasn't been used in a long time. And it seems like it seems a stretch argument to me. It's one thing, it's like, if it's used and you turn it off, well, you can turn it back on. That's one thing. But when you don't even have it in the first place, even though something can be equipped with it, it seems like the plaintiff's lawyers would be, kind of again, like a reach on this. Do you think this is a stretch for an argument, or you think this is feasible argument that some courts will entertain seriously?
Well, of course, we're going to argue the opposite, right? We're going to argue that it's just use. We're going to argue that it's not capacity if we can. I think that's going to be difficult because the statute has the word capacity in it. Regardless of what the Supreme Court has said, the statute written by Congress says capacity. It should be relevant. It's in the law. I think we'll argue that interpreting capacity in the way that plaintiff lawyers envision doesn't make sense in light of very clear direction from the Supreme Court. But that said, I'm not the decision maker, and none of us are on this call. It all comes down to individual judges across the United States who look at this question and have to make their own decisions. And they come with them their own biases, their own thoughts about what the law should be. There are also folks that probably get calls that are unwanted or that they don't like receiving, and they come with that experience and those opinions when they look at these issues. So do I think that there are going to be some judges that are going to look at this and find an expansive reading? Yes, I do, because we've already seen it. Time repeats itself. Over the last several years, even with the win in ACA International, we ended up with a circuit split on the issue of random sequential number generation that went up to the US Supreme Court. There will continue to be a disagreement among courts on how expansive this law should be and what the meanings of key phrases are. So I'd love to be able to say, listen, we're fine and it's a great ruling, and it is, but I think a lot remains to be seen on what the lower courts do with this. And it's going to come down to individual judges across the circuits.
Yeah, no, it's a good point. I agree with you. And I also, and we had talked about this, in our preparation for this webinar, the Supreme Court in this Facebook decision specifically repudiated the Ninth Circuit. They overturned Marx. And as you said, judges are human beings and they probably don't like being overturned. They thought that Marx was good law. So I don't think that they're necessarily going to take this lying down. I think that it would sort of be natural to expect them to have some sort of pushback or retort to this decision, which I think plays into your point that, the final chapter has not been written and probably will never be written. with compliance and the TCPA, it just keeps on going and going and going. So I think particularly, at least for me, I'm going to pay particular attention to the Ninth Circuit and see how they react to this, because I do expect some kind of retort from them in some way.
I do as well. And another thing worth mentioning is the Supreme Court went out on a limb to not only say that the Ninth Circuit got it wrong, but then went on to say that they already think that Facebook has a system that's not an auto dialer. That was well beyond the scope of what the Supreme Court should have been ruling. It already remanded the case to the Ninth Circuit to make these types of decisions, but the Supreme Court just went out on a limb and said, well, I'm just going to say it's not an auto dialer. It's at the motion to dismiss stage, and I'm going to say it's not an auto dialer. And that to me is not only a very clear statement, but it is a signal to the Ninth Circuit of exactly what they want the Ninth Circuit to do. And they don't want any question as to what they will do on remand. But judges are people. They don't like to be overruled, and they probably won't appreciate that the Supreme Court told them what to do. So again, the Ninth Circuit isn't one necessarily to just take things lying down. I think if they feel strongly that this is a law they want to uphold and they want an expansive reading, they will find ways to do that. And one way is capacity.
Right. No, it's a good point. So in other words, the Supreme Court was not taking any chances that the Ninth Circuit would misapply the ruling and rule that somehow Facebook, even under the ruling, was an ATDS. They were basically saying, this is the ruling, and we're not taking any chances that you're going to get it wrong. That's the idea, right?
I think that is. I was rather surprised that they went that extra step, because it really wasn't for them to decide. They decided what the law is, and then the proper thing to do is to remand it back to the lower court to make further rulings. They went a step further because they know the Ninth Circuit. They wanted to be very crystal clear on what they thought the outcome should be. So again, the Supreme Court knows the Ninth Circuit, and I think that's part of the reason why they were very clear on what the outcome should be. The Ninth Circuit will do what they think they can do. They will, of course, respect the decision as much as they can, but they'll also look for ways probably to go around it if that's what the panel decides. And I would not be surprised if that happens.
Sure. Okay, well, let's keep going. The next point about that was prominent in the decision was the court said, we're not going to undertake any sort of human intervention analysis as prior courts and lower courts have done. Can you expand on that a little bit more?
Yeah, so for everyone listening, this is footnote 6. And I've said this in the last couple of days, but sometimes these decisions, the footnotes in them are more important than almost anything else in the decision. And it's certainly true for this particular case. A lot of stuff is in the footnotes, and those footnotes are going to be key issues to resolve going forward. One of them is the human intervention piece. The Supreme Court basically said, we're not going to do line drawing based on human intervention. We're not going to take that up. And of course, that issue was not before the Supreme Court. The question wasn't about human intervention. Remember, the question was about random or sequential number generation. So as far as I'm concerned, that footnote is dicta, which means it's not binding, but it is a hefty punch. What I don't like about this footnote is that it sounds like Marx. It sounds like the Ninth Circuit. Maybe this is a place where the Supreme Court and the Ninth Circuit maybe are starting to see eye to eye, is about the human intervention piece. But I read that footnote and I immediately had thoughts that sounded like the Marx decision, that human intervention, of course, is related in some capacity with your dialing system. Somebody's got to press a button. Someone has to upload a list. So of course, there's some element of human intervention, even for auto dialers. Now, this particular footnote is very dangerous because I'm already hearing from the plaintiff's bar that they're now going to argue that human intervention is not even relevant, that it's not important, that as far as they're concerned, the Supreme Court has abolished the element of human intervention. Now that is an unfortunate reading of that footnote. I don't think it's binding on the courts, but it doesn't mean that courts won't pick up on it and run with it. So I think we're going to have to deal with that particular issue, what the role of human intervention is going forward. I have some thoughts about it. Certainly we're going to continue arguing that it is relevant. In fact, this human intervention piece dates back to almost 10, 20 years ago from the FCC, where they said the basic function of an auto dialer is one that dials without human intervention. Now, human intervention is not in the statute. I think that's important to recognize. That is not language in the actual statute. But for years, decades now, we've been talking about auto dialer and the relevance of human intervention. To not have human intervention relevant would just destroy years of precedent. So this is going to be an issue that is going to be litigated as well. What role, if any, does human intervention play in deciding if your dialing system is an auto dialer?
Well, that's a really interesting point. So in other words, it kind of, turns it all around. So the Supreme Court said, no human intervention analysis. So in other words, the plaintiffs could say, it doesn't matter how much human intervention you have and have demonstrated in the past. That's not the question. So we can just dispose of that. So they would basically be arguing that an abundance of human intervention notwithstanding, your system is still an HEDS, let's say, because it has the capacity for random or sequential number generation.
100%, and that argument's already been made by plaintiff lawyers that I've spoken with. They've already come out and said human intervention is no longer relevant at all. It doesn't matter if you have a lot of human intervention in your particular system. They're now arguing that it's capacity to either store the numbers or produce the numbers, and that's what at least some plaintiff lawyers are going to focus on. So that's going to be a fruitful ground for, I'm sure, a split of authority on the level of human intervention and whether it even matters.
Yeah, well, it's interesting because, we've seen, at least in my opinion, a lot of courts before Facebook, get the TCPA wrong in various ways. And I think all the things you're talking about here give new opportunities for them to get it, for some courts to get it wrong. Particularly on capacity, and like you said, on human intervention, just ignoring human intervention completely and just focusing on capacity and then getting that capacity question wrong.
I think that's right.
Yeah, and then the last point, and then we'll go to the next slide, but the last point, just a quick point, this case had nothing to say. Obviously, it was not an issue regarding pre-recorded messages. And how the TCPA treats pre-recorded messages, correct?
That's correct. This decision has no bearing on the rules governing artificial voice or pre-recorded message calls. And it also has no impact on the do not call rules of the TCPA or any other rules of the TCPA for that matter. It is a specifically focused decision on auto dialer in the role of random or sequential number generation. So this means you still need to be very careful when doing pre-recorded voice message calls, artificial voices, and that would include voicemail drops, voice broadcasts, artificial voice calls, artificial intelligence, which is also could be deemed pre-recorded. So all those other rules, do not call, those are all still in play. They're unaffected by the decision.
Okay, great. Steph, can we go to the next slide, please? Okay, so potential responses to the decision. So we started talking about this, and Christine, it's really helpful to hear what you're hearing from plaintiffs' attorneys. Obviously, plaintiffs' attorneys are not going to be complacent with this decision and just resign themselves that they don't have a case anymore. They're going to seize on that capacity argument. They're going to seize on the human intervention not being relevant. Anything else you're hearing from plaintiffs' attorneys about how they're going to, adjust their strategy?
Well, they're not only going to argue all the things we've been talking about, but apparently some of them have roundtable discussions going on with other plaintiff lawyers. They are collaborating more so than perhaps they would normally to figure out a path going forward. They have their own listservs, their own meetings that they're currently doing, and they're figuring out exchange of creative ways to move forward in their cases. I think you might also see some interest on the plaintiff's bar in supporting any kind of congressional or lobbying efforts to get a bigger and badder TCPA to strengthen the law, because what the decision has done is it's a win. It's a win for Facebook. It's a clear win, at least when you read the decision. But that has now been met with a lot of backlash from Congress, from consumer groups, who are already lobbying to get new legislation on the books or to at least reform the TCPA. And I can see the plaintiff bar also partaking in that so that they can get an enforced and, you know, a more robust law going forward in light of the Facebook decision.
Yeah, it makes sense. Have you seen, just out of curiosity, have you seen anything tangible yet in motion as far as legislation being enacted in response to this decision?
Nothing yet, but we've had some pretty scathing press releases from Senator Markey, who was one of the original authors of the TCPA. He came out with a press release within hours of the Facebook decision, basically saying that Facebook's a terrible decision. It's going to result in all these unwanted robocalls and other calls, and that they intend to take swift action in order to correct the Supreme Court's error. And there's a bunch of other stuff it said there. It was a pretty pointed press release where it even said that if the justices start getting all these calls, they'll have themselves to blame. So
yeah.
It was over the top. It was over the top, the press release that came out, but it was pretty pointed that they plan to work on legislation. And as you know, Senator Markey has tried to get other legislation enacted back in 2019, so it's not his first time trying to do that. But the difference here is that now there's a decision that's a clear win for companies and for defendants. So he may actually get some more reception given what the Facebook decision is. There's now maybe as far as consumer groups are concerned, greater need for more reform. I have no doubt that they will be working on legislation and proposing something. You know, whether something's enacted or not is a separate question, but I have no doubt that we will see in pretty short order some legislation at least being proposed.
Yeah, I think I saw some proposed legislation out of the state of Virginia. I don't know what the status is, and this was pre-Facebook. So in addition to federal legislation, there's no reason why states couldn't also jump into this and enact something, correct?
Oh, absolutely. And in fact, this is an area where we see state laws really becoming more prevalent, where the state agencies and the state governments say, well, they see a loophole in the law and they feel the need to fill it. They feel the need to bolster their own protections for their own citizens. So very often when we see the pendulum swing in favor of companies and for the defense, what we usually see is a response from state regulators that try to help reinforce where they think the federal law might be falling short. So I would not be surprised to see state laws coming out over the next several months, or perhaps even just more state law enforcement. I mean, this is sort of the push and pull of this particular world, where the federal law is really robust and working. State regulators feel sometimes that they can take a step back, but now the pendulum has swung in favor of defendants, and state regulators are probably going to respond with its own view and its own enforcement and its own legislation. So I expect we will see that. We're already gearing up here at Manatt to be ready for new state laws, and we're watching those very carefully. But this is an area very hotly contested, very hotly debated, a very controversial area, and there's always a push and pull back and forth with this kind of topic.
Right. Now, would you expect, let's say we see some future legislation, let's say out of Congress, Senator Markey, let's say, something gets enacted, in December, say, would you see that as having a retroactive effect back to Facebook, so that if somebody might think, okay, I'm in a safe harbor zone here, with the Facebook decision, you think future legislation can reach back retroactively, and capture that?
The only way the state regulators can really do that is if they come up with enforcement actions that argues that this was always the state of the law. This is always how it was, and they're just enforcing it. And they may take a different enforcement approach. But to the extent they're going to do legislation, there has to be a notice period. There has to be some way, an implementation period going forward, because otherwise, whatever they come up with just simply does not exist. So they can take the enforcement route if they want to try to keep what they have and take a more expansive view of the law. But if they're going to come up with legislation going forward, they're going to have to actually enact it and then have it be with the force of law. So that's why I say it could be enforcement or it can be new legislation, depending on how that state approaches it. And as we know, some states are just more active in this space than others.
Sure. Just to switch the conversation slightly to the carriers, the carriers, we talked about unwanted calls, not illegal calls, but unwanted calls. And I think the carriers are under increasing pressure to do something about, robocalls and about unwanted calls. Do you see carriers reacting in any way to this potentially? Or certainly I would expect, or wouldn't be surprised anyway, if there's increased pressure on the carriers to have some sort of response to this.
I think there is going to be some pressure on the carriers. I think a lot already exists. I've been noticing over the last several months before Facebook that a lot of clients have been coming to us about complaints with carriers and new requirements that they have. I've actually been a bit surprised by some of the inquiries coming through from the carriers as to how they share information and things that are, normally something we don't see from the carriers. But with all the attention on call blocking, the Trace Act, and increased role of carriers, I do think they're under a lot of pressure to make things happen, to do what they're supposed to do under these new guidelines and these new rules. And it seems they're taking it upon themselves to have their own requirements. Some of the carriers don't even have the same requirements as one another. So sure, it's possible that carriers will also do what they can to monitor traffic or come up with their own requirements. And of course, as we know, if you want to do traffic on a certain network, it's up to that carrier to allow you to do it, regardless of what the law says, what the Supreme Court says. If you don't abide by their requirements, they may not allow your traffic. In some instances, the carriers can be the first and biggest issue you could encounter because they allow your traffic or they don't. So it's also possible carriers might start looking at increased requirements. They're already starting to do so on various things.
Yeah, we've certainly seen carriers block or filter, or actually block SMS traffic if based on content that they don't like. That's not unlawful, but that's just unwanted. We've seen some collections traffic being blocked. Now I think they have less discretion regarding voice traffic, but certainly SMS traffic, as you said, they get to regulate that traffic, and they could create additional conditions for that. So let's go to the next slide, Steph, if we could. Yeah, so we're going to get into some recommendations here. So if we go to the next slide. Great. So just, you know, some benefits of HCI, just to sort of bring this together a little bit. So as we know, HCI has been found not to be an HEDS in 9 out of 9 court decisions. Obviously, that's a big virtue of it. So that's definitely in our favor. We have that precedent. One thing that's another benefit of HCI, we talked about this before briefly, the pre-recorded messages. So HCI is programmed, I'm going to use this word capacity. HCI is programmed so it does not have the capacity to leave a pre-recorded message. It's blocked. It's the way that it's been engineered. You cannot package a pre-recorded message within HCI. So I think that provides a good fail-safe for not leaving a pre-recorded message. You know, between the court decisions, between the inability to leave a pre-recorded message, we still think that HCI is relevant. It's very relevant, and it does continue to provide powerful risk mitigation. As this discussion, I think, has revealed, the dust has not settled. It never quite, you know, gets settled. We're going to see plaintiffs' attorneys reacting to this in various ways. We're going to see federal legislation, perhaps, maybe state legislation. So I think a lot of what we're seeing is customers and people we're talking to kind of watchful, in sort of a watchful mode before they do anything too dramatic. Additionally, and Jason's going to get into this, you know, HCI not only is HCI, but it's equipped with other compliance and, you know, risk mitigation tools. So you don't only get the Tcpa angle, you get additional compliance measures and risk mitigation measures, you know, in place. So if we could go to the next slide, and Jason, I'm going to turn it over to you to take us through the rest of this.
Thanks, Mark. Yeah, you know, you heard it from Christine over and over again, and we're hearing it from you all on this call over and over again. Everybody's kind of in a wait and see, you know, what are we going to do next? And I think this is going to take some time to play out, but just in the spirit of as reminding most of you, and I think a lot of you are already using most of these tools today, but if you're not, just a quick refresher on how our platform is engineered. We have the 4 clouds that are designed for you to easily shift your business if you choose to, from manual to HCI to preview to quick connect. So all those are options. Again, most of you have those on your platforms today, and you're using them in some capacity based on your level of risk or even your client's level of risk. So let's hop to the next slide here, and we'll talk a little bit about kind of the differences in Quick Connect and HCI. The good news is that Quick Connect and HCI have a lot of the same or similar productivity metrics. Quick Connect is ideal for high volume cases, where your key goal and key objective is to keep that agent busy and keep that agent talking to customers. In addition to that, though, too, it allows you to have specific regulatory requirements, time of day calling, maximum attempts, those things that you're dealing with on a day-to-day basis already. We'll talk a little bit more about the CFPB rulings here in a couple minutes. But when you talk about making the strategic shift from HCI to Quick Connect, we usually see a lift of about 10 to 15% in production. That comes from a couple things. Understaffing your clicker agents, maybe an underperforming clicker agent. You know, clicker agent's great, but if they turn their back to go talk to a peer, calls don't go out. Quick Connect, you don't have that problem because it's launching calls systemically. Some of you will see much smaller of a lift. I mean, most of the folks on this call have been using HCI for so long that you've got your clicker agent staffing down to a science, and you've really got that ready time for your agents very, very low. So you may see no lift. Some of you may see a much more profound lift. One of the things that we like to talk about with Quick Connect in all of our offerings is most of the competitors in the space provision their products to offer between 3 and 6 lines per agent. That was a great offering in 1990. I think everybody on this phone call can feel the pain of understanding what connect rates feel like right now with call blocking apps, with crowdsource blocking. All these things out there in the landscape are giving us a connect rate of about 9% across our platform, meaning I have to launch 11 phone calls for every person I want to get on the phone for my agent. So that outbound capacity in Quick Connect and HCI should meet the pacing requires for any project you may have. And lastly, I don't think we talk about enough is when you talk about very, very low connect rates, it's imperative that you have best-in-class answer machine detection accuracy. And ours usually sits in the mid-90s, so most of you are feeling that today. But if you deteriorate that accuracy by 1-2 basis points more, your agent's productivity goes from talking to people to hanging up on answer machines. So that's a pretty big deal that we like to talk about. So let's hop to the next slide here, and we'll talk a little bit more about what that ROI looks like. Again, if you're using HCI today and you decide and your clients decide that you want to make a pivot in some of your calling to Quick Connect, you're going to see a lift of about 10 to 15%. So let's use an example here of a 100-seat contact center. If you're doing 41 connects an hour today, you may see that go up to 47. Again, we're not guaranteeing this. A lot of this has to do with handle times, connect rates, the way you staff your clickers, but this is just a model. The important thing to take away from this slide is that if you go to, maybe you dust off the dialer that's sitting in the back computer room and you plug it back in, and you've got it positioned at 5 lines per agent, you're going to see a profound reduction in connects per hour and a profound increase in agent ready time because you lose that line capacity. So again, taking that to a 100-seat agent, you're talking about a change of about 160,000 plus attempts in a day. So Steph, let's hop to the next slide. All right, we've talked a lot about CFPB rulings here in the last couple of months, and the good news is most of the folks on this phone call have already adopted PDAS in some capacity now. If you haven't, that means it's called a phone dial attempt supervisor. It's a way to regulate the number of attempts, the timing of attempts over spans of days, right? The core offering is, hey, don't call Mark more than 3 times in a day. No problem. But this starts to go a little bit more past that and starts to address those things like you can't call someone in Massachusetts more than twice in 7 days. Or the CFPB's latest ruling, don't call someone more than 7 times in 7 rolling days. So PDAS, in conjunction with other tools like state dialing rules, time zone, safe time zone, the do not call, zip area code mismatch, cell phone scrubbing, all these things together make for a very powerful compliance risk mitigation tool that works not only on HCI but also Quick Connect and our other offerings as well. Steph, let's hop to the next slide. I know we're running short on time. I'll get through this really quickly and I'll get us out of here. Speaking of the CFPB, again, we've done a lot of webinars about this. We've had a lot of conversation with our customers, and this is really another opportunity for us to have those strategic shifts to say, now's the perfect time to start talking about your digital engagements. These rulings we're hearing are about phone calls. They're not about text messages. They're not about emails, right? So we're actively championing and encouraging you to start that outreach, to start capturing that consent, start managing that consent, and start giving your agents that safe empowerment to have those communications with your customers in other channels that your customers are already asking you for. So that's a big message here. Again, and we also promote here, regardless of if you're using Quick Connect or Preview or HCI, the CFPB rules still exist. And if you're not using tools like speech analytics to make sure your agents are saying and doing what your data is telling you they're saying or doing, you're setting yourself up for a pretty big blind spot. Last point on this slide is many of you that are using PDAS today are going to start incorporating multi-channel strategies like we just talked about. And as of version 16, which is kind of late spring, early summer, PDAS version 16 will cover multi-channel maximum attempts and time controls on that piece as well. So let's hop to the next slide. Maybe the other big popular topic of the day right now, right? Stir shaking. I think everybody's ready for this. It's looming on the horizon here at the end of June. I want to remind everybody on this phone call that LiveVox has been proactively at the forefront of the Stir Shaking project for 3+ years. We are ready to go. We are ready to deploy at the end of June when the regulators and the carriers are ready to go to ensure that your phone calls are getting that authentication, getting that permission, and getting launched to your customers successfully. In addition to that, today we're already tracking your connect rates, we're tracking your call outcomes, and we're tracking your blacklisted numbers. Everyone's feeling the pain of the blacklisted numbers. I think we changed out 55,000 numbers in the last 2 quarters. It's an ongoing process, and we couldn't be more excited for Stir Shaking to show up and hopefully take some of that pain away. One more slide here. Let's talk about the key takeaways, because I know that that Mark and Christine and I hit you with a lot of stuff here. HCI still remains a very strong risk mitigation tool. I think that kind of the consensus from everybody is we're gonna kind of status quo. We're gonna do what we're continuing to do. We're gonna watch the landscape. We'll adjust as our legal teams and the landscape suggest that we can. If you're interested, we obviously do have Quick Connect. That's what we call our dialing solution. If you're not using it today, if you have no familiarity, with that tool today, reach out to your account team. We'll have some conversations about it. It's very simple to do, but we want to make sure that all of your other settings, all of your other guidelines, all of your other rules translate with that strategic shift, right? We don't want to leave max attempts or do not calls in the wayside because you make a shift to another dialing strategy. Again, most customers are going to see a 10 to 15% lift from moving to HCI to Quick Connect simply by taking the human intervention piece out of it. Offsetting volumes to digital channels, great idea, great strategy. Again, if for no other reason than giving your customers a great customer experience and starting to build that consent library. Lastly, our compliance controls cover not only the things we've talked about today, but we're spanning TCPA, CFPB, FDCPA, DCPA, and more. So I know we talked about a lot. I'm going to turn this over back to Steph and Mark here, but I would encourage you, if you still have questions, if you're not certain about what strategic changes to make next, reach out to your account team. We'll get somebody from my team on the call with you, and we'll make sure that you're doing things safely in a way that you're not putting your customers and your clients at risk.
Thanks, Jason. So you might have mentioned this before, but just to emphasize, if you have, obviously the Facebook decision is only 5 days old, so there hasn't been a lot of time to react. But certainly I can say that from what I'm hearing and what I'm seeing, and this is not scientific, we're seeing the wait and see approach. We're not seeing any dramatic shifts, any dramatic movements. You kind of, can see numbers on the platform. And is that's what you're seeing as well? We're not seeing like this mass migration over to auto dial.
Yeah, it's obviously we see these rulings and we're like, hey, what are our customers going to do? And across our platform, we are seeing a net zero migration from HCI to Quick Connect right now. That may change, but from day over day, we are seeing no change.
Okay. And Christine, it sounds like, just from your comments, I'm going to guess that you're not advising your clients just to dramatically switch over. It's something that they should probably consider pretty carefully because there's still, Facebook notwithstanding, there's still exposure here. There's still risk to be had.
Absolutely. We have had some clients reaching out to us asking if they can make changes to their practices. I've gotten questions about removing TCPA disclosures. I've gotten questions if they can move over to a predictive dialer. We've gotten many variety of questions that you can possibly imagine, but I think this is, our general approach to this is let's understand what it is you want to do. Let's look at your particular system. Let's take a look at the ruling, and then let's figure out if you can make changes and if we advise making changes. I don't think this is a situation where any company should just look at this decision and say, oh, well, Facebook won, so we're good. Let's just power up the dialer or make switches and we'll be fine. My fear is that there are a lot of companies that are probably not as sophisticated as LiveVox customers who will do exactly that. They will see the win with Facebook. They will make very drastic changes in their compliance. And I have a sneaking suspicion they may be calling me in a couple of months in the latest and greatest TCPA class action. So this is a situation of wait and see. It's not to say you can't make changes, but I think you need to carefully consider them. You need to speak with your counsel, and you need to understand the risks of going forward. So not to say no changes are appropriate, but I think this is something you need to carefully consider. Take the time to figure it out and then decide as a business, is it something you're comfortable doing and undertaking the risk in light of the new landscape? And of course, this landscape is going to take a while to really formulate. I mean, it's 5 days old, the decision. It's going to take months and months to figure out what lower courts do. And then when the lower courts rule, they get appealed. They get appealed to courts like the Ninth Circuit. And ultimately, those federal circuits are really going to be in charge of whatever the view of this law is for their particular jurisdiction. It is going to take time. It's going to take some time.
Right. So as before, we're in a risk management landscape. Maybe, the variables have changed a little bit, but ultimately it's risk management. As you said, Christine, what your goals are, what systems you're using, how much productivity you're looking for, how much risk mitigation you're looking for, and then balancing all that out, I think is the way to go. So Steph, I'm going to turn it over to you. I don't know if we have time for any questions. We can certainly get back to people afterwards, but what do you think on questions?
Yes, I think as we watch the questions fly by, as all questions that are legal related questions, I think they might take some time. So what I'd like to do is, I see a couple folks who had raised their hands. If you haven't had a question and would like to ask it, I'm going to spend the last 3 minutes giving the opportunity to input them, and then your account managers will reach out to you with some answers that we can gather from this team. There's questions ranging from specifics all the way to SMS usage. So please feel free. We've got 3 minutes left. I will open it up and we'll make sure to document them and get back to you. In the meantime, we do have a couple of available assets. Again, we'll be sending a copy of this recording, but there are a couple of documents that might be of interest, including the ruling itself. If you are like Mark and Christine, bedside read these legal rulings, you're free to. There's a couple of their items around our CFPB, Sir Shaken, and the 4 Clouds assets. There's links to this. The presentation will also be sent. As we wait for the fallout, I just want to remind you that your account management team, the business consulting team, our legal counsels are behind you. We are actively monitoring the feedback, actively monitoring the progression of the rulings and our client behavior. If you have any questions or would like to set up a follow-up, please reach out to your account management team. In the meantime, I want to thank Mark, Christine, and Jason so much. These are probably the busiest 3 people that you can find since Facebook sent out its ruling. So I really do appreciate you guys coming on and giving us some deeper insight into the ruling. And I think we've been doing these TCPA webinars for a few years, and just like all the other ones, we will see what's next. It's never ending. So thank you guys again. I hope you have a great rest of the week, and I hope you join us next time.
Thanks.
Thanks so much, everyone.